Welcome to KTVB Inside the Courtroom, the Vallow trial. I'm Andrea Dearden, and we're glad you're here with us. We have had a week-long process this week to seat the jury that will hear the case against Lori Vallow Daybell in court beginning on Monday, so next week. We started with 1,800 potential jurors, a huge pool. These are Ada County citizens that were summoned to appear that potentially could be jurors. That pool then narrowed down, took several days to narrow it down to 42, then down to 24, and eventually we landed on 18. What do we know about our jurors that will hear this case?
Yeah, 18 jurors from, and I want to back up really quickly, those 1,800 were folks that were given a questionnaire. So summoned for jury duty, they had to fill out a 20-page questionnaire, and it took a couple days for the judge and the attorneys in the case, both the prosecution and the defense, to go through that questionnaire. You know, they could weed people out, whether they were going to be on vacation, whether it was very obvious they weren't going to serve on this jury. And then from there, we don't actually know how many they ended up with out of that 1,800 to begin this week of questioning. But they went through extensive questioning from, 8 or 9 in the morning until sometimes 6:30 in the evening, Monday through Thursday. And then they did something today called peremptory strikes. So they had the ability, the attorneys in the case, both the defense and prosecution, had the ability to strike people without justifying why. So the past 4 days, for those who haven't been following, they've been able to strike people, but they've had to explain why. So for cause, and say hardships in people's lives or bias, which has been the biggest issue, right?
Right. Too much information. They've seen too much in media. They think they know more about this case than they feel comfortable with them coming into it with.
Exactly. Yeah. And so how do you kind of whittle that down? How do you dwindle it down when so many people know about this case? And that has been the biggest issue. But, it brings us to today, where now we are left with 18 jurors. You've got 6 alternates, and 10 of the jurors are men. 8 of the jurors are women. We know that. We don't know their identities at this time. We've not been allowed inside the courtroom. We've been in an overflow room, and you can't see the jurors. And even when we are allowed inside the courtroom, we can't have cameras, as you've talked about, and we're not allowed to show the jurors or talk about them or talk to them. There are a lot of rules around identifying who they are. But going back to who the jurors are, it's been difficult because, like I said, we can't see them, but also there are times where, they're asked to raise their hand or raise a piece of paper, and they're identified by numbers. So it's difficult to track any of the traits about these individuals.
Or where they come from, their age, what their occupation is. We just don't know
We
that.
don't know any of that, But we do know that a lot of them have at least heard something about this case.
And that was something that was certainly a part of surely about the questionnaire, but also as those questions got a little more pointed and a little more specific, as that number got whittled down to that final 18. Clearly they want to know, is there a bias there? Or it's not that they can't have heard anything about the case, but more prosecutors and defense attorneys wanting to make sure that, do they feel comfortable that these men and women can make a decision based on what they hear in the courtroom and not what they think they know or what they have heard previously.
Yes, exactly. And we talked about this with multiple defense attorneys as well as prosecutors that we've been leaning on as experts in this case. I asked, is it about who you don't want on the case, or is it about who you do want to serve on the jury? And they said it's actually both, Well, from the prosecutorial side especially, ideally it's who they want. But from the defense side, it's more so about who they don't want. But it really is a combination of both, and I've had attorneys refer to it as a chess game of sorts. I mean, it really is a science, and it's very, very specific.
And there are people, there are experts that do just that. That they are brought into cases to examine jurors, to sort of kind of read the potential jurors, to look at, it's kind of much like a profiler would in a criminal case, or in a criminal investigation. It's that reading of what do we think they're going to do, kind of what their thought process might be. So it is, you're absolutely right, it can be a pretty extensive science. You did talk to former Ada County Chief Deputy Prosecutor Gene Fisher, so gave some insight on why or how that questionnaire that you mentioned really did help whittle it down, right? Let's hear what she had to say about that.
All of the really big questions, a lot of the theme questions, a lot of the concerns, I'm sure were addressed in the questionnaire. So when they whittled it down to 42, it definitely made it much simpler last night to go through those. They had to do a lot of work to get there, but at least they already had their questionnaires for the 42 that they knew were picked. And so I think that probably sped things up quite a bit. And having moved the case here to Ada County, where we have a much larger jury pool and population.
Serving as kind of an expert here, and that's exactly what this show is meant to do. So we are going to be able to have the journalists who are there watching this trial, and we're going to allow those, be able to talk to these experts. And so she's not directly connected with this case,
no,
but clearly a lot of experience in a courtroom, a lot of experience with criminal prosecution, understands the process, and is going to, people like Jean are going to help us as we follow this case day by day. She's going to be one of those people that we lean on to really kind of help us understand
exactly
what's happening and why.
Exactly.
So these 18 jurors, we know 12 will be actual jurors, 6 will be alternates, but no one in that pool knows which they are.
Exactly. And Jean talked about that. She said the reason, nobody wants to let them know in advance is because you don't want any juror to be disassociated, to be disinterested throughout the trial. You want them to be paying attention day in and day out, not making any, conclusions about the case, not talking to anybody about the case because they don't feel like their duty is as important as an alternate. So they won't know until deliberations, until all the evidence is presented. And I'm sure you know this, Andrea, but Jean was explaining to me, I thought it was fascinating, that they'll pull numbers out of a hat.
Yeah.
And they'll go, okay, these are 12 jurors. And then if they have to swap anybody out, say, for example, in an unfortunate scenario, which is very rare, somebody learns something about the case, right, and then they, maybe spread that information to one other person. Well, then they've got to take those 2 jurors out of the deliberation and swap them out with alternates. At that point, Jean told me, they have to start deliberations all over again.
Exactly. And that is something they want to avoid. And that the judge made no, he didn't mix any words here when we talked about the wanting to make sure that jurors understood their responsibility. We're talking about 8 to 10 weeks. This is not a sequestered jury. It's not unheard of to have a jury in a case like this have to stay in a hotel room where everything that they have access to is monitored, everything from books to magazines to TV. That's not the case in this trial. And clearly, you understand the cost of that is extensive, having to monitor that and make sure, and also is a huge disruption to someone's life.
Absolutely.
Sitting on a jury is a disruption enough, but to have that be 24/7, certainly something that judges are very hesitant to do if they do not have to. However, that also means that the responsibility to follow the court order has to be followed specifically. And so what were his instructions? What is he telling him?
Yeah, he spoke very candidly. I wish I had some of it verbatim. I mean, I could find it, but he essentially said, this is your oath. You swore under oath that you were going to follow my instructions. And if you don't follow my instructions, you could be held in contempt of court, right? He said, do not talk to anybody about this case. Do not research it. Do not watch the news, read the news, listen to the news. If anything is under your control, don't go about seeking it, right? Don't go about asking somebody questions or, inviting that in a way or seeking something out on TV or in a documentary. If something happens and it's kind of out of their control, he said, if something comes on the TV, mute it, walk away, because they are not sequestered. And so he could, however, sequester the jury at any time. I mean, he said that. So that's not out of the question if any issues arise. Hopefully they do not. But he said he and the attorneys have full confidence in this jury that they will be able to follow instructions. And so I think as a juror, you go, I know this is a high profile case, right? How much pressure are you under? But Jean talked to me actually last week when I interviewed her about the mental health of these jurors too.
Yeah, right.
And they're going to be seeing some really horrendous things. I mean, we all are. We actually learned today that the public, whoever's in the courtroom in the overflow room, is actually going to be seeing the same evidence that the jurors are going to be seeing and the judge and the attorneys are going to be seeing. So autopsy photos, some really sensitive material about kids and death and the nature in which they were found and the manner and where, and so that weighs heavily on jurors, which is another reason you've got to have alternates, right?
Exactly.
But another reason that you just don't want them talking to anybody about this case. And I also wanted to mention, I forgot to say, going back to the questionnaire, I know this is sort of off topic, but she actually said that this was really fast for a jury to be selected. Yeah. Whereas I remember this week we were all, oh my goodness, like it's redundant in voir dire when they're questioning and individually questioning. But this is quick, 4 days essentially, and then a peremptory strike challenge.
Yeah, it's quick. And it's because, as Jean pointed out, that they had the ability to, they had a lot of information. And so they were likely able to kind of immediately weed out some immediate concerns.
Right.
Anybody who was close to the case potentially knew witnesses or had more access to media. Exactly, had more access to information by nature of your job. And then they got into some of those interesting questions, and we did talk about that last time about understanding circumstantial evidence, and could you in fact be willing to could you convict, or could you believe that somebody did something based on circumstantial evidence, and a lot of talk about that. Also talked about the show CSI, and that something that we certainly think about in criminal investigations. CSI, you solve the case in 60 minutes minus commercial breaks.
Right.
You run a test, and the lab results pop up on a screen. That's not real life.
Given you have blood or something to show
the DNA,
it.
It matches immediately, and so they are able to, the fingerprints and all that, and that's just not how real investigations work. I mean, it takes months and months. It's not always conclusive. There are sometimes, questions about and potentially even some contradictions when you look at different pieces of evidence. And you talked about the egregious nature of the concealment of these two children. Prosecutors have brought that up in different hearings, and we've talked about that. And so we know that likely there will be a lot of that information, and potentially, I think that those questions of the jurors definitely point to that. Is that we may not have definitive. This is how this is how this person died.
Yes.
Exactly.
They're sticking by the fact that they believe it was a homicide.
Right.
They have said publicly during voir dire, during asking the jurors, what if we don't know how one of the victims, they've said that explicitly, how one of the victims died, would you be able to still find somebody not guilty or guilty of a crime? And, interestingly, as we've reported, Vallow Daybell is charged with murder, conspiracy to commit murder, and grand theft. So she's got multiple charges. If she's not found guilty on one of them, they could drop it to a lesser offense.
Sure.
Second-degree murder, perhaps, or find her guilty on the other one or two offenses. And so I think when we talk about circumstantial evidence, it's something that people that aren't involved in the legal system aren't aware of, and that means evidence that has to do with circumstances related to a situation. It's text messages leading up to it. They gave the analogy throughout questioning of the jurors of a bank robbery. So you've got a bank robbery, you've got somebody with the gun, you've got somebody with the money bag, you've got the person in the drive-away car. Is the person in the getaway car as culpable as the person who pulled the trigger or who held the gun to the banker's head? So that's kind of the good analogy, and we heard that over and over again. But that's one way to think about it. And in the modern times that we live in, like you said with CSI and Law and Order, all these shows and series on Netflix that we watch, I think the common person, potential jurors, might believe that that's how you have to convict somebody, and it's just not true. And circumstantial evidence and evidence in general is also witness testimony.
Sure.
And you can choose whether or not as a juror you want to believe somebody or not.
Sure. And you will undoubtedly have different perspectives, different views, often of the exact same information, the exact same evidence, different experts, evaluating that differently, coming up to a different conclusion. And it is up to these jurors to determine what that is and what that really means ultimately in the ultimate outcome of this trial. And that's what they are here to do. Beyond a reasonable doubt, is this woman guilty of these charges?
Exactly.
Right? One of these charges, all of these charges, none of these charges. That will be up to these 18 people. 12 of them will make that decision. Right. But 18 of them will sit through this entire case.
Yeah, and the state asked, do you understand kind of the fundamental process of how this works, that it is on the state to prove. It is beyond a reasonable doubt, and they have the burden of proof. It's not, the defense doesn't have to prove anything, right? Right. They're here to defend their case. Yeah. In fact, we'll get to this in a bit, but they don't even have to give opening statements if they don't want to. Right. So I think a lot of people, again, going back to the lay person who is a person called for jury duty, might not know how this works, and they are going to learn. And they've learned throughout this past week, and they are going to learn a lot more next week as well.
What about Lori's demeanor this week? What have you been able to see? I know access, we've talked about, very, very limited. So because of the jury selection you talked about, we want to, the judge was very clear. They want to protect potential jurors. And certainly if you're not selected and, you want to protect that identity. So no one has been allowed inside the courtroom, only in that overflow room that they're calling it. So very limited kind of screen access, right? Yeah. And kind of blurry, not super clear. Yeah. So have you been able to tell kind of what her level of engagement has been, what her demeanor's been like?
Let me tell you, it has been very difficult to see, because if I could set the scene for you guys, we're in the Ada County Commissioner's room. So it's on the main level. It's a large room. There's a lot of seating. That is going to be the overflow room throughout trial. So that's the room that I'm personally going to be in, so I can do live shots. And in this room, it's dark. There's a big projector in the corner. And in that projector, there's 3 boxes. And they're live streaming from inside the courtroom, courtroom 400 in the Ada County Courthouse, the biggest courtroom. And you can see the judge, you can see Vallow and her defense team, and you can see the prosecution. And it is really hard to see. Yeah. Unless even if you're front row, it's hard. I had to put on my glasses because I was like, squint. It's really difficult. But as you get closer, you can see a little bit more. It's tough to follow her demeanor. There were a few notable things this week. She actually, at one point, and I don't know if this was the case today, hard to tell, she had a notepad and was taking notes. You saw her talking to her defense. She's got a big defense team. Archibald is her main criminal defense attorney, public defender, and he has a very successful record. It appears that, she's unknown what their relationship is, right? But it appears that she's been able to talk to him back and forth throughout. And she's been wearing, we've been reporting on what she's wearing, and I know some people aren't a fan of that. I think for us, we're the eyes and ears. Right. In the courtroom.
Giving access to at least giving you some insight. Some insight,
right?
Yeah.
And for TV people, that's different because we always get our cameras anywhere,
Sure.
So it was the judge's decision to not allow cameras inside the courtroom or audio recordings either. So anyway, we've been kind of outlining what she's been wearing, and she always kind of dresses interestingly, differently. She has her hair curled. She's wearing makeup. She's worn glasses a couple days. She'll wear a turtleneck and a blazer and a cardigan. And so we've just reported that to ensure that we're communicating as much as we can with people. But at one point, I saw her, and the sketch artist actually captured this. I don't know if we can pull up the sketch. It might come up a little bit later, but Vallow at one point was wiping her eyes or cleaning her glasses. It was really hard to tell. And that was when I wasn't personally there, but as my colleagues reported, that was when the charges were being read, I believe, or something about the nature of the victims in which they were found. So I want to verify that. But it's been really, really difficult to see her, and I hope that changes. You see her there with her hands folded. The notepad in front of her, that's her defense attorney. I hope that moving forward we're able to see a little bit more, because it's challenging if you're not inside the courtroom.
Right. And we know, we so appreciate, those of you who have commented on, asking about different things about her demeanor, different things about, wanting to know a little bit more about this case. And again, that is exactly what this show is intended to do, is give you a little bit more of that in-depth look at, the day-to-day, week-by-week happenings inside the courtroom, but understanding that there will be that challenge throughout this case.
Yes.
So we simply will not have anything short of a sketch. We hope to have audio from the day's hearing, but again, we don't know for sure. We hope to have that each day, but we don't know when that might happen and when we will be able to share that. But certainly we will do the best we can to bring as much of that detail to you as possible, again, with the sketch artist. Then, of course, then the reporters and folks who are at the courtroom
on the ground. I mean, that is the only way. What you just saw is the only way we're going to be able to visually depict. And we've got a great sketch artist, Lisa Cheney. She's been in the overflow room with us, drawing these photos. And this is what she'll do every day. There have been days where she's produced 5 photos for us, and it's been our visuals and how the public can understand what's going on. A lot of media organizations, not everybody, but a lot of media organizations chipped in to pay for this. And so this is what we're leaning on, and she's done a really wonderful job. We actually Brenda Rodriguez did a story with her this morning about, her interest in this. And so you guys can watch that on our website, by the way.
So one of the questions that was kind of outstanding this week was whether or not J.J. Vallow's grandparents, Kay and Larry, would be allowed inside the courtroom during the case. They actually made a motion to the judge because if you are a witness in a case, you are usually not allowed to be in the courtroom. And it makes sense. They worry that a witness could hear other testimony, they could hear other information that would potentially, even unintentionally, skew their own recollection of something or their own statements. However, Kay and Larry argued they are advocates, that they are not just witnesses in this case, but that they are victims in this case. So what do we know about their access now?
So they got an attorney. They lawyered up last week. I believe it was last week, and they said, we believe that we are victims and we deserve to sit in every minute of this trial. And they have been very vocal, as anybody who's followed this case knows. They have been the ones that we've spoken to, that multiple news outlets have spoken to. So they filed to be, understood as victims, and a judge just ordered, 2 days ago, it was filed yesterday, that they will be allowed inside the courtroom. Kay Woodcock, the grandmother, will be allowed inside the courtroom. Grandpa of J.J. Vallow, Larry Woodcock, will not be allowed inside the courtroom until after he testifies, because Kay and Larry are both witnesses. We're expecting. The witness list is sealed, by the way, and it will remain sealed, we learned. The judge will keep that under seal, mostly because of Chad Daybell's trial still to come. Right. So the witness list is sealed, but we likely know that they're going to be witnesses, and the judge ruled Kay is a victim. She can sit in. So can Lori Vallow's sister, Summer Shiflett, Colby Ryan, Vallow's son, as well.
Her oldest child.
Her oldest child with a different husband. And Larry can come after. He just can't be in the courtroom initially until after he testifies.
So Colby would be Tylee's older brother, and of course considered himself JJ's older brother as well.
Yes.
So JJ was adopted by Lori Vallow and her husband at the time, Charles Vallow, Charles is actually Kay's brother. And so it is a little bit, it's a dynamic in that he was a nephew. However, biologically was born to Kay's son and his wife. So they do have a biological connection. I mean, that they are his grandparents. And so the judge ultimately ruled that while they didn't have a motion, they really didn't have a legal reason to argue to be in the case, in that courtroom. So he really didn't even weigh in on the motion. But what he did say was that they can appoint an advocate, which means she can be the eyes and the ears for that victim who cannot be there themselves. The court does allow for that. And so that's where the sister, Lori's sister, is going to be, she's considered the advocate for Tylee. Okay. Kay considered the advocate for JJ. And then allowing Colby in, didn't add advocacy there, but just said that he was allowed to be in the case. In that, a victim. Exactly.
Yes.
In that courtroom. And that is really, that is what the law allows. It is an open forum in terms of this is the people's court. And so these proceedings, while they are limited, there is a legal, a legal reason, if you will, to allow for folks to be able to watch and understand what's happening. That's the way our court system was designed. And so that really was the argument. And now Kay will be able to be in there. And I think that obviously made a huge difference for that couple.
Gosh. I mean, and you think about it, sometimes, victims aren't afforded the rights that they always deserve, and sometimes they're just seen as a member of the public and they get things when everybody else gets things. And so I think that because they have been so vocal and they have been such strong advocates, it's pleasing to see that they got this,
So opening statements, we know prosecution will make opening statements on Monday. You mentioned defense does not have to. Do we know do they expect to?
We'll see. Everything in this case is a day-by-day situation. I mean, we didn't know when opening statements were going to start. We didn't know when the jury was going to be selected. We thought maybe it would be today. We thought maybe it could be 2 weeks. So the defense has the ability to waive their right to present their opening statement and wait to present their case until they call up their evidence and their witnesses, and just let the prosecution go first and not show any of their hand, if you will. So we'll see on Monday, what they decide to do. And again, going back to the whole setup of this is on the prosecution to prove beyond a reasonable doubt that Lori is guilty of the charges they're alleging.
And so that's where we're going to get that insight into what the strategy will be. That's really will be the first time that the prosecution really lays out that full case and ultimately will tell the jury, they will roadmap what they expect to be able to show and ultimately what they are hoping to be able to prove with what we believe to be as many as 200 witnesses.
Wow, yeah.
And, we will not know, as you said, we won't know who those are until they are called.
Right, we'll track them.
Of course,
But interestingly, too, I when you think about 8 weeks, that's a long time.
Sure.
So they have a lot of evidence. Both sides have a lot of evidence, a lot of people that they're calling. As I mentioned, witness testimony is considered evidence in a case. And so that is going to probably take up most of it. You've got cross-examination, you've got redirect, all these sort of legal lingos that the attorneys can go through back and forth. They can call witnesses back.
Sure.
But 8 weeks is a long time. And so we're going to learn a lot. And I think from, the defense perspective, it'll be interesting to see whether or not they do decide to give any sort of inkling as to what they have on the first day. But we do know opening statements are not arguments.
Right.
Opening statements, they will not be going back and forth. They will, like you said, simply provide a roadmap, say this is who you're going to hear from. This is what we're laying out in our case. This is what we believe happened.
Right.
And then the jurors go, okay. And again, do not make up your mind yet, jurors. That's kind of what they're instructed.
Sure.
Keep an open mind throughout trial. That's the big thing. Keep an open mind. And then we'll see if the defense does the same.
Yeah. And we will be watching that. We will be sharing that with you as well. As you have questions, we've already had a couple of people ask, what about the name, right? Lori Vallow or Lori Vallow Daybell. Let's make it clear that in the court filing and in her booking on these charges, she is listed first as Lori Vallow, right?
Lori Noreen Vallow.
Yeah, so middle name included, Lori Noreen Vallow. And then a.k.a., also known as Lori Noreen Vallow Daybell. And so we have used those names interchangeably. However, it is Lori Vallow written, in as that legal. On that complaint. Exactly, which is why, we understand that's the name that we have kind of deferred to, calling it the Vallow trial and such. But that question did come up. And so both names are listed, but it's an a.k.a. in terms of adding that Daybell on there. And that's something that we understand. Yeah. The Vallow family, very sensitive to that. So she is no longer married to Charles. In fact, he was killed.
Yes.
And so, understanding that, and certainly that was a question that came up that we wanted to try to answer. If you have other questions that you want us to try to answer, please, you can text those to us. That number here, 208-321-5614. Ask that. We will try to research what you want to know, because we do want to take you along with us as we follow this case and hope to bring you that inside the courtroom as things happen. So Morgan, you will be there, and we will continue that coverage as we move into the next week and the start, really official start of this trial that will last 8 to 10 weeks.
Yeah,
so
we'll be learning a lot more, and I think that this is a great platform for us to be able to really dive into it and explain the process more. So grateful to be able to have this, and you can follow Shira Matsuzawa, Alexandra Duggan, and myself on social media, as well as all of our coverage on KTVB.com, the KTVB Plus app, YouTube, and I think I covered them all. We've got a lot of platforms.
We will get all of those and get all that information to you as we are able to. So thanks so much for being here with us today, and we will see you very soon.